Okay, welcome everyone to Lunch with the Leader. I am Ellen Mills and I'm filling in for Carol Ann. She is traveling. So there is water on the back and I'll keep refilling that if you'd like. But I'm really honored to be able to introduce our speaker today. This is Magistrate Judge Catherine Taylor. Just quite the resume, but we're just going to move. What is this? Oh, that's for the, got it. We're just going to move right into, she was elected as our magistrate judge in 2022, and she's speaking on the anatomy of a court case, from arrest to sentencing, and the rules of law that guide that process. So please enjoy.
All right, thanks, Ellen. Oh, thank you. All right, so I have not timed this, so it may be 10 minutes, it may be an hour, we'll find out. And I also want to preface it by saying that I welcome all your questions. Just know that I can't answer questions about any cases that are pending or might be pending in front of me. Okay, so the anatomy of the court case. This is kind of our overview. There it goes. So there's a couple different ways it's going to get to the courts. On your tables there are handouts and there's some extra ones up here. These are some of the documents that we'll go over. If anybody wants to grab these or some pens. So basically, and just to be clear, this is a very broad overview. We could spend years studying this process, but a crime is committed. There's two ways it's going to get to court. The officer sees it, there's a stop, there's all those steps, they'll detain, investigate. There's two ways it's going to end. It's going to end with a warning, like don't do that again, or an arrest. That means they're being taken into custody, or a citation. Basically, like when you get a traffic ticket, right? They're going to have you sign it. They'll give you a court date. You show up to court on that date. What we're going to cover in our example, and there's some handouts on the table, are crimes that are reported to the police. You call 911, you flag down an officer, that kind of thing. And this is sort of the steps that it takes. You can see there's an investigation. There may be a search warrant if they need to gain access to a container, a vehicle, a home, your Snapchat, like those types of things require search warrants. Then these are the types of things. Can I just see how many of you have ever been on a jury? Has anybody had jury duty? Okay. So you'll see things like physical evidence, circumstantial evidence. There's nothing wrong with circumstantial evidence. It's totally acceptable. And they're going to be arrested, taken into custody, or cited. Same thing. They're going to get a citation or they're going to get a summons from the court telling them they have to be to their case.
What is the V and what is the W?
I'm sorry. Thank you. V is for victim. W is for witness. Okay, so these are just screenshots of the items you have on your table. So I wrote these. They're not real, obviously. This is basically what I am going to see when the police department submits the case to the court. And I will note, it's interesting, most of my work when I was a prosecutor was in California. The DA's office files cases in California. The police departments submit their cases to the district attorney. The district attorney makes the charging decisions and files the cases. In New Mexico, that happens at the police department, which take that for how you want to. So it's going to be, this is going to come from the police department, not from the district attorney. All right. So if you read through the fact pattern, and Wolf is arrested, and if you would read through it, you would see that at the very end of the narrative, or the probable cause statement, is how the officer contacted Mr. Wolf. So he saw him walking, I think he was walking, right? Yeah. He was walking down Trinity. He sees him. He knows him because it's a small town. And he flags him down, or he calls out to him. So right there, we're not in detention status yet because he said, "Hey, Wolf, can I talk to you for a minute?" And Wolf comes up to him. A lot of times people will say, "Well, I was talking to the police officer and he didn't Mirandize me." Well, you weren't in custody. You were just being detained, right? So you are not under arrest. Miranda won't apply. Okay. Wolf is arrested without a warrant. A warrant is basically a document that a judge has to sign to say, yes, I think there's probable cause that this person probably did what you're accusing them of. I'm going to sign it, and then that will justify them going and finding the person and taking them into custody. Here, Wolf is arrested because of what the little pigs reported, right? The officer didn't see this happen, but he's going off of the victims and the witness statements. This requires a probable cause determination. That's the PC within 48 hours. That is made by me or any judge. So I'm going to get those documents, the complaint and the probable cause, and I'm going to look at those, and I'm going to be looking for the elements of the crime and think, is it probably him? It's a pretty low threshold when you think of, like, if you've been on a jury in a criminal case, the threshold is beyond a reasonable doubt. That's the higher standard of proof in our system. And it's kind of individualized. Different people kind of have different thresholds that they think is beyond their reasonable doubt. A PC determination is kind of low. It's kind of like, they probably did it. This is only for custody. This is only for that threshold level. If we're talking about trying to prove someone guilty or find someone guilty, it's a much higher level of proof. Okay, so this is where I think it kind of gets interesting, and I get a lot of questions about what's the difference. I don't know if any of you know Judge Elizabeth Allen. She's our municipal court judge, and we have people come to the courthouse all the time. My court is on the second floor, and people still will climb those stairs or take that elevator to come upstairs only to find out their case is actually on the first floor in municipal court. The difference is municipal court hears city code violations. So when you hear about code enforcement or all the people, they're going to revise the code, those things are heard in municipal court. So Santa Fe has a municipal court. Magistrate is a state court. I only hear state violations. So if you were cited for a state code violation, like Mr. Wolf was here, then you're going to be seen in magistrate court. Oftentimes, the police department, felonies always have to start in magistrate. But you will often see the police department, there's a lot of overlap between the Los Alamos Municipal Code and the state statutes. All the officers have that discretion as to which court they want to bring it into. And those would be questions for their department as to why they choose one way or the other. So this one kind of forced its way into magistrate court, right? Because they knocked over 2 houses. So in municipal court, the city code or the Los Alamos County Code, you can have the same charge of criminal damage to property, but you'll note, and that's my highlight, that's not in the code, not to exceed 1,000. So that's for damages 1,000 and under. Obviously, with our damage to 2 homes, our damage has exceeded $1,000. Presumably, probably, that's going to be an element of proof at the trial. But on the face of it, it would be like, yeah, it's probably going to cost him more than $1,000, especially in Los Alamos, right? All right. So that's how it's going to come to my court. It's going to be based on the charge, and the officer has some discretion unless it's required. So the first court date is going to be called an arraignment. They're basically the same thing. It's an arraignment for traffic and misdemeanor charges. It's a felony first appearance when it's a felony. And that's what we're going to be dealing with our example. So these are the players that you're going to see at that first appearance, whether it's a felony or a misdemeanor traffic. I shouldn't say that. Traffic, you're not going to see, at the first appearance, you're not going to see a defense attorney or the state. The state can be either represented by the district attorney or by law enforcement, depending on the severity of the crime. So let's say in our case, though, we're focusing on Mr. Wolf. You're going to have all these players at the first hearing. In this case, because it's a felony, you're going to have the district attorney, maybe the law enforcement, maybe Corporal Christie might be there as the case agent, but for purposes of a felony first appearance, they don't need to be there. The defense attorney, that's the logo for the Law Office of the Public Defender. That's a statewide agency. We have one that is assigned to Los Alamos County, although she has to cover other counties as well. Both these offices, both attorneys' offices are notoriously shorthanded. But I think that's a nationwide issue. Okay, so what we're going to do in your forms, in the little packet, and I don't know if I had enough, but you can share. If you turn to the second, well, I guess it's kind of the third page because I double-sided them, you'll see the felony first appearance sheet. And so what you're going to do if you want to. You don't have to. We're going to go over this, and basically this is what's going to happen at the first appearance. There's the advisement of rights, and I can recite it for you. I have it memorized. I'm going to advise you of the charges and penalties. I'm going to ask you if you want an attorney. If you cannot afford an attorney, or can you afford your own attorney, I'll give them a deadline to have an attorney enter an appearance. And then I'm going to, on a felony, it's going to be an automatic not guilty. I'm going to enter a not guilty plea. Because it, yeah.
So you said the defendant's lawyer would already be there at the first appearance?
Could you start over?
Yes.
This is for the two that they just asked the question.
On the slide before, you said the defendant's attorney would be there at the first appearance, but now you're saying that you ask them if they have a lawyer?
That's a good
how does
question.
that go?
So the public defender, we're very fortunate because Ms. McCleary is our public defender that's assigned to Los Alamos. And we have a set every day at 2 o'clock. That time's going to change. Every day at 2 o'clock, we hear whatever has come in the day or weekend before. So she's assigned to these arraignments, basically, for felony first appearance. Even if she hasn't entered on the case or the person has not qualified for the public defender's office, it's a financial qualification, she can still represent, I shouldn't say represent, I allow her to appear as a friend of the court. So she's there basically as counsel. She's not their attorney in the sense that we recognize that she represents them, but she is there to advise them. Don't say anything. I don't think you should say that. Please don't do that. So she's kind of there for advice if they want. She is not technically their attorney. So, but that would be a good point for when the public defender is there, even if they are not appointed, meaning they haven't entered on the case, they're still there available to satisfy the right to counsel. And it's pretty, I was going to say 50-50. It's really not. It's probably more like 75-25 in Los Alamos that most people go with the public defender. In other counties where I cover for judges on vacation, it's almost everybody goes to the public defender. So here we are at our felony first appearance, and we're going to look at our sheet, and this is put out by our database. So my clerk prepares these. They come in a file. It's a different color than this one, but it comes in a file, and the colors depend on what type of case it is. So you can look at one, like a green one is traffic. The misdemeanor, depending on the charge, like if it's a alcohol-related one, it's going to be blue. There's different ways that the clerks classify those charges. This one's probably going to come in a yellow folder. So I'm going to identify Mr. Wolf. He's going to come into the court in custody with the detention officer. He's going to be handcuffed. He's going to be in his jail clothes. And then I'm going to advise him, I'm going to determine whether or not he speaks English. And then if I get a sense that maybe it's not his first language or maybe he's having trouble understanding, then we'll inquire if we need an interpreter. If I think that someone, and this is kind of an aside, if I think in my kind of introductory, like, oh, tell me what's your name, what's your birthday, if I get a sense that maybe they're not competent in a legal sense, then I am going to, on the court's own motion, I'm going to kick it up to district court because I don't have the authority to refer someone for competency, but I can say I think this person should be screened for competency, but that determination has to be made by a district court judge. So at that point, let's say Mr. Wolf does not need an interpreter. So I am going to advise him of his rights. I'm not going to go through that now unless you really want to hear it. I'm going to check the boxes that he's been advised of his rights. We don't have the advice of rights video in our court. And then I'm going to go through these questions. Do you understand your rights? Usually, yes. And then I'm going to advise them of the charge. You've been charged with criminal damage to property. It's a violation of section 30-15-1. That's a 4th degree felony. That penalty is up to 18 months in prison and a $5,000 fine. You have a second count, same charge, same penalty. Do you understand these? Yes. Do you want an attorney? They almost always say yes. If they say no on a felony, and it does happen, then we kind of shift gears and I go through this whole thing like, you realize you're facing prison time. These charges could be sentenced consecutively, which means that your, your 18 months in prison could be 36 months in prison because I'm going to sentence you one after the other instead of concurrently, which would mean you'd serve both of them at the same time. And sometimes they'll start to get it, but if they insist that they don't want an attorney, then I have to go through a whole colloquy of what's your highest level of education? Do you speak English as a native? Do you take any medications? Are you on medications right now? Like, you're trying to establish that they are knowingly and voluntarily and intelligently waiving their right to counsel, because it will have very serious ramifications if they want to represent themselves. In New Mexico, it's called pro se. California, we called it pro per. It's the same thing. So we're at our attorney. Yes, let's say Mr. Wolf does want an attorney. Can you hire your own attorney? If he says yes, then I give them the EOA on the form, tells me entry of appearance. I give them a deadline. Usually I'll say, do you have someone in mind? It kind of varies. A lot of people will say, yeah, I've already talked to so-and-so, or, oh, my parents have already hired this person. A lot of times, though, they'll say, I'm going to hire my attorney, and then when they start talking to attorneys, they quickly realize they can't afford it. So if they come back, well, that's kind of an aside. Let's just say Mr. Wolf cannot afford an attorney. I'm going to refer him to the public defender's office, and then I sign something, but that's basically saying it doesn't automatically appoint them, because the public defender, and again, these would be questions for their office, they have to do a financial assessment because they've got rules that they have to follow as to whom they can provide those services under the statute. Okay, so here's where we skip down, and we're going to get to, where are we? So the probable cause on our sheet on the felony first appearance, you'll notice there's a couple different things. So found prior to first appearance, back when I said, oh, he was arrested without a warrant, I had to make that probable cause determination within 48 hours of that arrest. And I will mention, it's 48 hours, no matter what. If it happens at 2 a.m. on Saturday night, it has to be done within 48 hours from that point. So there's a lot of other things as far as timing in the statutes and in our rules. There's like the 10 days, and if it's less than 10 days, you only count the business days, but if it's more than 10 days, then you can count every calendar day. There's all kinds of little lawyer things. When it says hours, they mean literal hours, 48 hours. So those have to be done pretty much right away. So when I get to the probable cause, I'm probably going to check the box on Mr. Wolf's case that I found it prior to the first appearance. I probably found it, within hours of him getting arrested. It will be sent to me by the jail. If I don't see it, or if, let's say I don't remember what time he got arrested. It's like somewhere around 3 o'clock, right, when he got picked up. So probably they'll get me the stuff by the evening. I'll look at it, and I'll probably sign it before midnight. If for whatever reason it was that fast, say it was a weeknight, and I saw it Monday night, and he was there on Tuesday afternoon, I'm probably just going to say found at first appearance. You'll see if it's not found, I've never checked that box, but if it's not found, then that means the person would have been released immediately if probable cause was not found, either when I get it on the email or if I determine it in court when I look at it. Probable cause would not be required if the person was summoned to court. They're out of custody, so you don't need probable cause. They're not detained. Okay, so this is where I think a lot of misinformation might be in the general public. So conditions of release. I'm sure you guys have heard that New Mexico is a catch and release state, and all these terrible judges are just letting everyone out. This is why. So this was a constitutional amendment, and you probably remember back in 2016, this was on the ballot. This is what it said on our ballot. And so I'll give you a minute to read it. Sounds totally reasonable. 87.23% of voters in New Mexico, yeah, this sounds great, right? We're granting courts new authority to deny release on bail pending trial for dangerous defendants in felony cases, while retaining the right to pretrial release for non-dangerous defendants who do not pose a flight risk. Of course everybody voted yes, right? So the Eighth Amendment gives you the right to bail. In years past, and when I was practicing, we had bail schedules. So whatever the charge was, it had a corresponding bail amount. And shockingly, or maybe not shockingly, those bail amounts were set by judges. So they could differ county to county. And again, I don't know how they did it in New Mexico. I wasn't practicing back then, but I imagine it was very similar. That was kind of the practice throughout the country, is you just follow schedule is what we called it. We're asking for schedule. So you would look at the charge when the person would be there for arraignment. The state would say, we're asking for schedule. The defense or whoever, the public defender probably, who's just got a stack of custodies to go through, is going to argue why it should be set lower. And the DA might argue why it should be set higher than schedule, but mostly the judges were going to just default to schedule. So what came about in or around building up to 2016 was the idea that by setting a bail amount without regard to the person's circumstances was having a harmful effect, because people were getting held in custody because they couldn't afford the scheduled amount, right? Let's say it was $10,000, and you can't post a bond, or you can't get someone to post it for you, or you don't have collateral to put up to get a percentage, with the bond agents. So people were losing their homes, they were losing their jobs, they were losing custody of their kids, and it's just like kind of a spiral. So that was kind of the thinking behind, like, we have to do away with bail. Everyone has a right to we're innocent until proven guilty. So why am I sitting here just because I'm poor? When, maybe somebody with terrible, terrible crimes, $1 million bail because they, almost killed someone or did kill someone, they can just post it and be out. And I over here because I shoplifted, laundry detergent. So that was kind of the thinking behind it. They put this to the voters. It obviously passed. This is what is now in the New Mexico Constitution. And this is where I think it gets interesting. I don't know if this was put in front of the voters. My understanding, and from what I remember from that ballot, if I can remember, was just that blurb I showed you a minute ago. And that's what everyone voted for. But then this is what went into the Constitution. And it has a lot of legalese, right? But these are things that I think were lost on probably 87% of 87.23% of voters. Bail may be denied by a court of record. Magistrate court is not a court of record. So that means that there's no court reporter, there's no recording. It's kind of weird because the Supreme Court did mandate that we be recorded, but we're not a court of record. Supposedly it's to protect us in the event that there was a security incident, or if somebody, well, that's how they told us. But it's really to make sure. I think it was a checkup on a lot of magistrates. There's a lot that are not attorneys, and I think that there may have been some issues in some other courts that made the Supreme Court think that they wanted a little bit more oversight. So despite the fact that we are recorded, we are not a court of record in this sense. So bail may be denied by a court of record pending trial for a defendant charged with a felony if the prosecuting authority requests a hearing. So this put it back on the DA. So when you hear like, well, why'd that judge, they let out that person, they committed this horrific crime, why'd they let him out? If it meets a certain threshold and there's certain criteria, the DA has to initiate that motion. That it's called a detention motion. If they choose not to, we are bound by the constitutional amendment and by the rules that were then put in place by the Supreme Court. We are bound to release the person. We have to. So this is the other part where we get hung up. And there's some cases, if anybody really wants to read them, they finally came out with one that reviewed an issue out of Metro Court in Albuquerque, where the Supremes finally gave us some guidance as to what exactly constitutes clear and convincing evidence that no release conditions will reasonably protect the safety of others. So if you go in the code sections and the rules sections, I didn't put them here, they're pages and pages long, but if you go in there, it has a list of criteria, not limited to, including but not limited to, that the judge can consider in setting those conditions of release. But it comes back to the Eighth Amendment that you can't make it too onerous. You can't make it too much, because then it's effectively a detention. All right. A person who is not detainable on grounds of dangerousness nor a flight risk in the absence of bond and is otherwise eligible for bail. Everyone is eligible for bail unless it was a capital offense. That means that, well, Capital when New Mexico had the death penalty, so first-degree murder, they no longer do. But a capital offense still includes life without parole. So you cannot be detained solely because of your financial inability. So there are a lot of times when I will have someone there that has failed to appear. It's an FTA. This is how we shorthand it, a failure to appear. And they have a history of failure to appear. The judge does have the discretion to set a bond. But this is where it kind of gets kind of like, why bother? You can set a bond, and you have to articulate why, and we have it down to where we've, like the judges in our district kind of have like a checklist. You have to have articulable facts to support why you're setting a financial bond. And in that case, I would say, well, they're a flight risk. They've FTA'd like 10 times on, 6 different cases, or even worse, in, the case that's in front of me, let's say, and we're farther along in this process. I'm like, they've already failed to appear 3 times. So this time I'm setting a bond. The problem is if they do this, and it goes to district court, so I don't necessarily see it, they can appeal it. They can take it up to district court and petition district court to say, I can't afford it. Like, this isn't fair. I don't have that money. So a lot of times I'll set a bond, and then we're required, because now they're in custody, we have to keep up with them so they don't kind of fall through the cracks and we, run out the time clock on getting the case to trial. So they have to immediately be set for a review. If they remain in custody and say, it's because I can't afford the bond, then I either have to reconsider it, reduce it, eliminate it, or say, no, you've got a history of failures to appear. I know you're not going to show up because you haven't showed up 6 times before. I'm leaving the bond. Then they can appeal to district court. And then district court's going to do what district court does. So this is the rule that we're required to follow. And again, this rule, 6401 and the 4 series and the 6s, these are the rules that the Supreme Court gave us from that constitutional amendment. So I'm still questioning how we got from that to this, and by whom? Like, if this was the constitutional amendment because the voters voted on this, like, who are the people that are putting this from here? So, again, but the Supreme Court is a court of superintending control over the rest of the courts in the state, so what they say, we do. All right, so your pretrial release. So Mr. Wolf is now in court. We're in our felony first appearance. We've gotten down to the second half of the page, and we're talking about pretrial release. So I typically, I set my conditions at the felony first appearance. Technically, I could wait 3 more days, but why? It's just a hassle for everyone, especially if they're moving people from jails to jails. They've got to drive them all over the northern New Mexico. We just set the conditions at the felony first appearance. They do have a right to counsel. So that's another reason why the public defender is scheduled to attend, even though she's not technically entered on the case. But if they want to talk to her or want to ask questions, or she will advise them, like, don't say that, don't admit that, that's what they're there for. You have a right to be released without bond. The wording is, you shall be released with the least restrictive conditions that reasonably ensure the appearance and safety of another person. I will share that this is one of my pet peeves, that if you go through these rules, reasonably ensure the appearance and safety of any other person, they'll change that article a number of times. Sometimes it will say, or the safety of another person, or they'll leave it off entirely. So we're always kind of like, well, isn't that a fair consideration? Shouldn't we be able to consider the ensuring appearance? Sure, I'm confident he'll show up for court, but can't I also, make sure that it's the safety of another person? Here it would look like it would be. In other sections of the rule, it will say or. And so these are things that are really frustrating to me, that they're not consistent, and it kind of doesn't give us the guidance that we need, because we're following the law, to be like, wait, well, here it says or the safety, so I'm just going to go with that, even though I think he's going to come, and then it'll get taken up on an appeal or on a writ to say, well, that judge did it wrong because you had to say, I was going to appear for court, and she said it was or when it should have been and anyway. So I talked about the written particularized reasons why, the conditions, and why I might want to set a bond. And I did, when I very first came on the bench, I did set a $1 million bond at 10%. It was only 10%. But to me, and in my background, that was apparent. And I did follow through. I went through all the factors that were required. I did consider the flight risk. I did consider the household income, and I thought it was an appropriate bond. Others did not feel the same. So, may consider any facts tending to indicate a failure to appear, but you shall set it at the lowest and with consideration of ability to post. So for somebody, let's say, that's on food stamps, $1 million bond would clearly violate this rule. Somebody whose household income was $250,000, probably okay. All right, this is important. You cannot set an unaffordable bond just to get around these rules. So same thing. You can't say, well, I'm going to set you're a failure to appear risk. You fail to appear in every single one of your cases. You have 10 other cases. I'm going to set a $10,000 bond knowing full well the person is homeless and on public assistance. Like, I'm just trying to say, I'm just going to keep you in because I know you'll never be able to post that. You are not entitled. You cannot do that. You're entitled to a review of that decision, and that goes to district court. And just by the way, I don't know if I cover this. I think I cover it later. We'll get into it later. So this is the next step. So this person has now, let's say Mr. Wolf has been released on his conditions, and on the back of the felony first appearance page is the order setting conditions of release. So we've modified it to fit our jurisdiction. The state form has one that allows release to a third party, which I've never used, and I don't think I ever will. I don't think it's appropriate to have an adult supervised by another adult. Usually it's a family member. The one time it was requested of me, it was a parent. But the problem with that is that you're essentially putting that third party into the position of law enforcement or probation or pretrial supervision. And I think that that's just a huge conflict. I mean, I think it's very rare the parent or friend or spouse that's going to really call the cops on their loved one if they're supposed to, say abstain from alcohol. Some people will, but I just think it creates way more problems than it's worth. So if you want to look over the order setting conditions of release, anybody want to say what they would set for Mr. Wolf? You don't know anything about his criminal history at this point, right? So we don't know if he has history of failure to appear. So this is probably just on the information before you. And by the way, this is all you get. You may have access. Sometimes I get access to a rap sheet. Sometimes we get the public safety assessment, which is basically it's kind of an algorithm. Nobody really understands how it works, but it'll give them a score. We have to consider it, but I personally don't find it all that helpful. I do consider it, but I don't really know. There's other things that I will look at to determine what I think is appropriate. And there are a number of questions I can ask the person. So Mr. Wolf, I could ask him, well, where are you employed? How long have you lived here? Do you have family here? Are you working? Are you in school? Like things, you kind of get a sense of what people's ties are to the community, and that will help you think like, well, this person's from Colorado. They don't work here. They were here camping one weekend. Their ties to the community are not great, and chances are they may not even, they'll just avoid New Mexico to, if they flee from this case. So in Mr. Wolf's case, we're probably required, I'd say this is going to be a personal recognizance release, and then we're going to set his conditions. So what is anybody, if you look at the conditions, and these are kind of preset. At the bottom, there's always the space where you can fill in your specific conditions. But in this case, Felicia, what would you give him?
Sure.
Anybody? So in this case, I don't have any information that there was any alcohol or drug use alleged. So probably not going to make that a restriction. He is an adult. The not buy, sell, consume, or possess illegal drugs, that kind of goes, in my mind, that kind of goes with the obey all laws. I mean, If there was drug use alleged, or if he appeared to be under the influence at the time of the arrest, because remember he was like sweaty or something when he was jogging or walking, if the officer said, you know, I could smell alcohol, or his eyes appeared glassy, or his pupils were blown, or whatever indication that maybe there was drugs on board, I might impose that. But for the most part, absent other information, I'm like, you're an adult. If you've got a medical marijuana card or recreational, like, okay. I am going to require the possession of firearms or dangerous weapons. I might impose that given the circumstances. These people talked about them being afraid of him. He had a reputation for threatening people. In this case, I would probably make a condition that he not possess firearms or dangerous weapons. This gets tricky in New Mexico particularly. A lot of people have firearms for hunting or for protection or whatever. The problem becomes if they may not own firearms, but what if his wife does? Or what if somebody in his household owns firearms? So when I say you cannot possess firearms, that means you can't even have access to firearms. So I'm very clear when I restrict that to say, does anyone in your household have firearms? Like, you know, when I was a kid, I didn't own guns, but my dad owns guns. And so it's very, very clear that if you reside in a household where someone has a firearm, they are now going to have to put that somewhere. Oftentimes they'll say, well, it's in a safe I don't have access to. And I'm like, okay, that's fine. Just understand, you can't be cleaning it. You can't touch it. You can't take a picture with it. All things people have done and then say, well, that's possession means in this particular case or in that example would be access. You must notify the court of any change of address. We always do that one because there's a lot of address changing. And then that happens to be, well, I didn't get the notice. How come I have this warrant out? Oh, my address was wrong. So we have to put the burden back on the person and be like, you have to tell us. We don't know when you moved or when you changed or when you got an address or now you're homeless or whatever it is. So whatever address you give us, that's where everything goes until you tell us different. I'm going to order they seek and consult with an attorney, maintain contact with that attorney. This is another one where I will make the referral to the public defender, but I always tell them, you have to call. It is a conditional appointment and it's conditioned on your application. So I'm saying, yes, you're going to get the public defender, but they're going to make the final call based on your income and the criteria they have to use. This one would be the two that are bolded, don't return to the location and avoid all contact. Absolutely, we would put that in Mr. Wolf's case. Not return to the location of the alleged incident, which would be and avoid all contact with the alleged victim or anyone who may testify in the case. So any other witnesses, including the pigs. I think all 3 pigs are considered victims. So let's say another neighbor saw something. So no contact. You can't be harassing people, being like, come on, man. You know, say it wasn't me. The one thing I will mention on the avoid all contact is a lot of times in domestics or in battery or assault on a household member, especially a parent-child, a lot of times there is a mental health issue going on, and even the parent they're still trying to parent, even though it's an adult. And so they will say they can live with me as long as they're compliant with their meds. And so what we'll do on that is we'll make it avoid all abusive contact if the victim requests that they do want contact. They just want some restriction. And then if something happens and the police show up, now they've violated their conditions. That would probably cover it, I think, for Mr. Wolf. We don't need the ignition interlock. That's on a DWI. And then they are going to be sent this form. They're supposed to read this part, and then they're going to sign it. They're going to fill it out, and this is what we rely on. So if whatever they write here is now going to be their address. So if they give us a bad address, it's on them. Yeah.
In that example, there's a violation.
I'm start over again.
In that example, if there was a violation and the police show up, do they run a check on the person and find out there are conditions? How would the police officer just pulling somebody over or showing up at their house know that there were conditions?
So that's actually a good question. In Los Alamos, it's a small community and it's a small police department. So that's probably a better question for them. I think a lot of these people are known to them. and they're going to know if they were on conditions of release. It may be through dispatch. I don't know, because let's say, for instance, in this case, I put them on pretrial supervision. It's not checked on here, but that's one of the other options that I would have, because I made these, I had to delete a real person's name, and I deleted a bunch of information off here. So it looks like I deleted the pretrial supervision. That's another thing that it's run by the state. I don't know if that is available when they run them through dispatch, if they're on pretrial. But so far, they've known. And I don't know if that's just because of their briefings, because they tell each other shift to shift if so-and-so was, arrested, or this person, maybe they run their immediate history, like, hey, we had contacts. The police department knows whose houses they've had contacts. So if they go to an address, dispatch is going to tell them last police contact this date, this date, this date, or whatever. So I would expect that that's how it would come to me. If they're on pretrial supervision and they get arrested, pretrial every morning runs arrests overnight, and then they're going to notify the court if they violated a condition, and getting arrested is a violation. Yeah.
How often do people actually leave New Mexico, and how hard is it to find them?
In Los Alamos, it's not common. It happens. It depends how hard it is to find them. It's how hard they want to stay hidden. If you aren't a career criminal, you could probably dodge the police for a while. The other thing to think about, though, is when the warrant goes out, only a felony warrant is going to warrant national or nationwide extradition. So if it's a traffic ticket or a misdemeanor, depending, it's going to be only in New Mexico. So if you get a ticket because you're driving from California to Texas and you get one in New Mexico, just don't come back, right? I mean, it's going to hold up your license in another state. We get a lot of those calls like, hey, I didn't even know I had this outstanding warrant from 20 years ago, but when I went to renew my license in Florida, they won't let me because I've got a warrant. So it will catch up with you unless you are totally off grid and don't have ID and don't take benefit. I think it'd be pretty complicated, but people do it. So felonies are the only ones that are going to go nationwide extradition. Any other questions? Yeah. We need my clerk for this. I don't know. We get a pretty steady diet of criminal cases. Civil cases are rarer. Surprisingly, I found out we had a call from somebody that does rental assistance that was like, I'm not sure, something's wrong with the database because we have it set up to alert on evictions and we're not getting any alerts. I'm like, we don't have any. I mean, not never, but she said, yeah, we've set it up for a couple months. We haven't gotten one case. And I'm like, yeah, I know. And there's reasons, I suspect, probably because if you get a 3-day notice to quit or you get a 7-day notice or whatever it is, I think most people are either curing it or they're just going. The eviction process is only going to happen if you refuse to vacate when you're told to, when you're lawfully told to. So I suspect most people don't want to mess with that. It ruins your credit. It's hard to get another place. Your lab clearance will be affected. So I think that's why. Social Services tells us, no, there are plenty of people that are being evicted, but it's just not going through the courts. The criminal, I would have to run the report, which is what the clerk does. We're not terribly busy. It's nothing like, I call Rio Arriba County when I cover down there, I call it the Wild West. It is nonstop. And Santa Fe is the same thing, except they have 4 judges. Rio Arriba has 2, and I would say they probably could use 2 more. It's busy. It's really busy. Which is, I'm always like, yeah, just call me if you need a hand, because we're not that busy. It comes in waves. Like, there'll be some days, but I don't think we'll ever be as busy as Rio Arriba or Santa Fe. And that's good. That's a good thing. So we've moved on. So we've released Mr. Wolf on his conditions of release. He probably would be on pretrial supervision, so I will fix that form just for another talk. The pretrial supervision program is run out of Santa Fe. Los Alamos County has an amazing pretrial program. I will just say that. I know this is being recorded. But the state mandated that we use their program. They are based in Santa Fe. They have 4 levels of supervision. Level 1 is the lowest, and it's just phone calls. They just call, you have a check-in. I think it's 2 calls a month, and it's mostly just to make sure that, have you had any police contact? Don't forget your court date. Fine. When you start moving up, the level 4 is the highest, and that is, I think, 4 calls a month. And then they can mandate the person to come and check in. The problem I have with the pretrial program that we're mandated to use now is, well, it's based in Santa Fe, and we're dealing with people that, as I put it, are already having trouble adulting. Things are already hard, right? If you're in the criminal justice system, things aren't going great. And so you add on to that, you're homeless or you're unstable in your housing, you may probably don't have a vehicle, and maybe if you do, is your license valid? Is it restricted? Is it suspended? There's all these complicating factors. And then to ask someone to go to Santa Fe for a check-in, that literally can take all day if you're relying on public transportation. All day. And our social services department is great. They work very closely with the courts. And so that has been helpful. But I think our county, and it is unique, I totally understand that. I think we would all be better off if we could just use our county program, because it is local, it is it's connected to the services in this county. So there would be no reason if you were unable to leave the hill, or you had other complications, my car doesn't work, or I can't miss work, and you're going to have to take a day off to, at least half a day if you're working during, regular hours, to get down there, park, go to the office, do your check-in, go back, drive back up here. I mean, it's just, to me, it's not as practical, and it's throwing another roadblock in the path of someone who is already facing a lot of roadblocks. But that's just my little soapbox. I will step off. All right, so he's out.
Sorry, I have a question about that. So you said the state said, who in the state?
The Supreme.
It was the Supreme Court.
Supreme Court.
And is there an opportunity for you to state your objections?
I have, and I was told you will use the state program. So, and I mean the program, it's fine. It's just not. Is it time? Is that it?
No.
Oh,
I'm just here to call.
Oh, he was showing me the time. Is that the end?
No.
Oh, okay. Yes, and I think it's coming from it's a statewide program, and they've rolled it out now in all the counties. I think we were very fortunate because we had an existing program that Judge Allen had set up, and it works really well because it's local. And so I know Mrs. Schweiner, Monica Schweiner, is the person that runs the county's compliance program. So it's both pretrial and post adjudication, so probation. And what is the advantage for us is, number one, that it's here. Number two, that people sometimes, like she has people come in that aren't even on probation because they don't know where else to go. And so they come there. And then she can say, oh, nice to see you again. Like, oh, great. What's going on? And then she can say, well, go to social services, or here, let's try this, or here. And again, I don't want to throw the state under the bus, but we're in a very unique situation in that we have the funding. We're not swamped with cases. We're not swamped with people in need. And so there's more of that individual approach that I think is a significant advantage that I understand is not the case for the rest of the state. So whatever it is, we do our best. And the one thing I will say that has been really helpful is that program is still there, and it still is able to fill in gaps. So supervision, the program that I use in Santa Fe is mandated. That's the one we use for supervision. But for assistance, Monica's still there. My gripe with that is you've got two cooks in the kitchen. And for the person, I checked in with Monica. Why am I getting a warrant for not checking in here? I checked in with Monica because, it's all the court, it's all the cops, it's all, it's all just one big entity. They don't understand the differentiation or the nuance. Like, well, Monica's, she's not your pretrial supervisor. That person's in Santa Fe. She's, she's here if you need her, but that's not going to count. It's just, to me, it's too many things, and someone's going to fall through the cracks. So in our pretrial, now this is where it takes the longest, when you say, like, oh my God, how many times are we going to come back to court? It's this stuff. This is where all the magic happens. So what's going on in the delay between being arraigned or your felony first appearance and the day you go to trial? It's all of this. So discovery is where the state has to turn over everything. Witness statements, evidence, body cams, car camera, all of it. Anything the state has in their possession, they have to turn over. There are certain deadlines that are codified. And I will note that the responsibility for discovery is, if you're the DA, and this is where you can get burned, is you are held responsible for things you don't even know about. So if law enforcement has something and they haven't disclosed it to you or turned it over to you or even mentioned it in a report and it comes out later, you're going to take the hit. I mean, not you personally, but you as the state, because law enforcement is considered part of the state, right? So that's very important for the district attorney, is that you have very good relationships with your officers and their departments to make sure that is a very smooth flowing highway, that everything is coming through in a timely fashion. Because if somebody comes back and says, oh, well, I didn't know that so-and-so turned in his body cam footage on that stop, and it comes out 6 months later or worse at trial, oh, well, I turned in my body cam, and everyone's like, what? You got a big problem, because now you're going to have a discovery violation that sometimes, maybe often, will result in a dismissal. You saw that in the Rust case. Motions. So motions are going to be filed probably starting with the defendant. Motions to suppress. They're going to attack the stop. They're going to attack evidence that was obtained. Attack the search if something was searched. So we're going to be hearing motions as it gets closer to trial, and we're kind of starting to narrow down what the issues are going to be and how the case is going to be presented. You're going to have motions in limine. Those are limiting motions. It's never like on TV or the movies. There's never going to be somebody walking through surprise witness, because by the time it gets to trial, everyone's going to know, well, the defense is going to know exactly what the state is putting on. Sure, things can come up. Somebody doesn't testify the same. You might have to impeach, or you might now have to call a different witness that was like, you heard him say that, right? Those things happen, but by the time you're getting to a trial date, everybody should know what you're putting up, what your exhibits are, what your issues are going to be, who's going to testify. You've got to give a witness list, all of that. A defense continuance is something I had never experienced until I was here, and it's kind of interesting. We call them diversion, but it's basically the same thing. The attorneys will work out something. It's usually between them. They don't have to tell me, but I usually ask. And they usually tell me. So defense continuance would be, like, for instance, in our Big Bad Wolf case, that the DA and the public defender for Mr. Wolf, say the attorney comes to the DA and says, look, he was off his meds, he has no criminal history, this was a totally out of left field, he's super remorseful, he's already gone to inpatient therapy or inpatient residential treatment. He's going to be there for 3 months. How about if he does this, and this? At the end of 6 months, you'll dismiss the case. And so that's kind of what's going on. Those kind of negotiations are going on. If the state agrees, then it's what they call a defense continuance. Meaning the defendant in criminal cases, they're controlling the clock, right? So they have rights, and there are timelines that they have rights to have their case brought to trial. And if they're going to get a defense continuance and the state's going to allow a delay to see if he can comply with all these, he's going to jump through all these hoops, then they're going to make them waive time. That means that they're going to add time on to the deadline that they'd have to bring it to trial, because if it all goes to hell, then if they're going to have to put on a trial later, they need that extra time. So defense continuance is basically a negotiated settlement, kind of. It's usually kind of off the books. There's no record of it other than what the attorneys have agreed on. And then if they come in and say, we've agreed to a defense continuance, we're willing to waive time for this period of time, then I make the note and it just gets kicked down. We set it for a status conference out past that deadline, see where we are. Usually what happens is that if the terms of the defense continuance have been satisfied, the state will file a dismissal, and that later hearing just gets vacated and I never see it again. So sometimes it's hard to keep track of, like, oh, well, whatever happened to that case? Well, they just dealt with it and it got dismissed. And that's kind of like settlement negotiations. So they're going back and forth, kind of the same thing. If the state's like, absolutely not, this is going to trial, I can tell you, I'm not speaking for this district attorney, but when I was a district attorney in another state, settlement negotiations, there are some cases you have to take to trial. And you have to, because it was in the paper, because your boss is up for re-election, like whatever it is, you have to go to trial. You're not going to settle the case because it looks bad, right? Remember though, ethically, you cannot take a case to trial as the DA unless you can prove it beyond a reasonable doubt. So it has to be a provable case, but so many cases get settled because they're expensive, they take a lot of time, take a lot of jurors' time. Most criminal cases settle out by plea, and so settlement negotiations are happening from day one. The only time that they're not going to settle is where the parties are either too far apart, or it has to go to trial. It just has to. All right. So then this comes down to so then it's a plea or a trial. So we'll just kind of skim over this really quick. Negotiated plea agreement. There are two different ways that those are going to come through. There's only so many things you can really negotiate. For instance, if you have a DWI, there's a lot of mandatory pieces. You can't negotiate them away. There are mandated requirements as far as the punishment. So in a negotiated plea agreement, there's kind of two ways you can do that, where the state recommends or the state agrees. So if the state agrees to the proposed the plea agreement, they've already negotiated the sentence. If I don't agree with it, then the defendant has the right to withdraw their plea because the parties have agreed that that's okay. It's rare, but it does happen. So if there's circumstances where I'm like, no, this was a serious charge, this was, you've got a victim, and I think that you're really underselling this, I'm not going to accept your plea agreement. I can only think of one time that happened. And it was not a terrible case. It was something kind of minor. And then there's also the ones where the state will recommend but leave to the court. That's risky for the defendant, right? So if they check the box that says we'll recommend and they recommend a sentence and I don't agree and don't follow it, the defendant's on the hook. Like they rolled the dice and they got a worse outcome or sometimes a better outcome than what was recommended by the state. So it's a risk. An Alford plea is allowed in New Mexico, and I know we're getting into really small details. Basically, an Alford plea is where, I don't know if this happened in the Idaho killer, what was that guy's name? No, it's a KN name. Anyway, I don't know how he pled exactly, but for instance, in something like that, where you're not going to admit guilt, but you acknowledge that the state has enough to prove your guilt beyond a reasonable doubt, although you maintain your innocence, you are allowed to make an Alford plea. And what that means is you're basically saying as the defendant, I'm going to take this deal because I know what my punishment is versus going to trial and having a jury find me guilty and all this stuff coming out and then the judge sentencing me to something way worse. It's basically you're kind of trying to modify the risk. So you're allowed to maintain your innocence, accept the plea without having to admit guilt. I have never done one. I don't think I would sentence someone that wasn't admitting their guilt, but they are allowed in New Mexico. These are other little notes. A bench trial is just in front of the judge. There's no jury. A jury trial obviously has jurors. For those of you that have served as a juror, thank you. A misdemeanor, you only get 6, which was different to me. When I was first starting out and we did misdemeanor jury trials, they were 12. But here, a misdemeanor jury trial only gets 6 jurors, a felony gets 12. So this comes up a lot, you guys. And I'm just throwing this in here because I just learned this too. So you guys get the postcards in the mail when you get jury duty. We get calls all the time. I just got called. Why am I getting called for jury duty again? I've already served on a jury, blah, blah, blah. So there are 3 courts that you're getting summons for. And they are magistrate court, district court, and federal. They pull, and this is what the jury, I forget what her title is, the jury coordinator? Anyway, she runs the juries. They pull, and it's automated, so they don't really have any way to cancel each other out. They're pulling from 3 different databases. And it's the MVD from your taxes and from voter registration. And your name conceivably could come up for all 3 of those courts at the same time. So I don't know if they're going to fix this. I don't know how they're going to, I don't know, because she said that the way the information comes in, the way they fill their jury pools, is it's coming in from those databases. So chances are you could get named from MVD and voter registration. And you could be assigned to a magistrate and a federal. So it's just, so don't be alarmed. It's not a mistake. It's because the way that they pull the jurors is that they're pulling from 3 different databases and they're slotting them in. And so if you got called in magistrate court and then 2 months later you got called in district court, they're separate courts. So you're gonna be eligible. Okay. Sentencing. All right. So this always throws me off on TV shows. So when people say, "Oh, they're going to prison," you only go to prison if you're sentenced on a felony. Like, prison is different than jail. Jail is here. It's at the police station. Jail, you're going to spend time in jail or be sentenced to jail if you're sentenced on a misdemeanor. So a DWI, a misdemeanor battery, those types of things. If you are convicted of a felony, you could be sentenced to prison. I only keep felonies until the preliminary hearing stage. So in Mr. Wolf's example, for instance, we would have a preliminary hearing. It's just a probable cause hearing. I've already made the probable cause determination, but now it's the formal hearing where witnesses are going to come in, people are going to testify as to what happened, and it's still that lower standard of proof. But once Mr. Wolf's case, let's say he comes in, they do the prelim, it's bound over, meaning I find probable cause to bind the case over to district court. That felony case moves up to district court and everything else happens there, including any sentencing. So I don't sentence to prison. I can only sentence to jail. Probation and parole are basically the same thing. It's just they correspond. Probation goes with jail misdemeanors and parole is post-prison. So you're paroled. Does anybody have any questions about that distinction? People use jail and prison interchangeably. They're very different. They mean something very different. And then finally, you have a right to an appeal. We talked a little bit about any decisions that are made at the lower level court and magistrate court. So if you don't like your conditions of release or you think I shouldn't have set the bond, you can petition, you can appeal to district court. Those go to district court. If you get to district court, like Mr. Wolf, when he's bound over and has his trial in district court, if he's not happy with that and there's an appealable issue, that district court decision first goes to the appellate court. And if there's enough issues, I guess, with it, or if the Supreme Court decides that it's something they need to weigh in on and say, trying to think of a good example, something where there's still confusion or there's still an issue that needs to be decided so that people can move forward with their decisions, then they are going to certify that for review and it's going to go to the Supreme Court. Once the New Mexico Supreme Court weighs in on it, that's it. That's the law. I mean, we're not going to go into how it gets to federal court and appealing that high, but for our purposes, this is as far as Mr. Wolf would be able to go to the Supreme Court on whatever issue that he's alleging. The reason that it's going to end up in the Supreme Court is because, let's say the appellate court overturned the district court, and then the state appeals. Let's say district court finds him guilty, he appeals, the appellate court says no, the prosecutor committed misconduct, so we're going to vacate that. and then the state says, oh no we didn't, they're going to go to the Supreme Court, and then the Supreme Court's going to look at the entire record, including all the way down to magistrate, which again is only recorded, it's not a court of record. They can only look at the paper, but they're going to look at the entire court history and say whether that decision, like, nope, the appellate court was right, or nope, the district court was right. And then they hand it back down and say, follow our direction and either resentence, retry it, do whatever they need to do. All right, that should be everything. Any other questions about this super quick and dirty overview?
This isn't about what you presented directly, but the issue of homelessness is before us every day. What happens in Los Alamos? Well, you tell me what goes on in the country, which is not something you may be able to answer, but I bet you'll have insight.
Yeah, I think you should have someone from social services come and talk to you. Jessica Strong runs the social services here, and she's got tremendous knowledge of the nationally and locally. There are homeless people in Los Alamos. I don't know. A lot of people are like, no, there's no homeless people here. There are. They're just not visible or as visible. A lot of them are either sleeping in cars, camping, staying with friends, that kind of thing. So I don't think we're fortunate, and then I don't think it's as big an issue as it is in a lot of other places, especially Santa Fe or Espanola. And I mean, I'm sure we could all speculate it's probably because of the lab, and I think that they're very aware of who's where and who's doing what and who are you, and but it's there. It's super expensive. I think the last I heard, the cheapest rent was $17.50, and I don't know what that was for. I don't know, but if you're a family and it's a studio apartment, I mean, I don't know. So I don't know what. We don't see, I shouldn't say that. I don't see it because that's not usually an issue that's before me. The only time that it's shared with me is when we're having problems with failures to appear. We can't reach them, which is another reason why I prefer they check in up here. But there are people that are homeless, and what their circumstances are varies. And I think there was some talk or some things that I'd heard. I haven't verified this, so I wonder if it's just sort of anecdotal or people just being kind of, not in my backyard. There was some talk of like, well, people are just coming up here from the valley because there's more available, there's more resources, and possibly that's true, but there's nowhere to stay, and it's hard to get up and down the hill if you don't have a ticket or a car. Not to say that people don't do it, but so I don't know what the answer to your question would be, other than, yeah, it's here.
Is it illegal?
Is it illegal?
At large, is it illegal to be homeless?
That is a very good question.
I
can't speak to that. I don't know what the county codes are. I'm not aware of any state statutes that prohibit it. I don't know, Judge Allen would know about the county codes as to whether it's criminalized here. I don't know. But I think that's a bigger discussion as to whether, I'm sure there are people that absolutely are like, no, you can't just camp out in the park. That's for everyone. It's not just yours. So I think there's a huge faction of people that would say it's criminal behavior. But I think that's a pretty big philosophical debate. Yeah.
So at this week's county council meeting, Councilor Righty had mentioned a program called Sequential Intercept Program, and that sounded interesting. I'm kind of curious if Los Alamos County is looking into that, and I guess my question is, if like our substance and mental health programs were fully functional, like how many cases would that eliminate from your workload?
That's a good question. And the sequential intercept we did. We had, Los Alamos County has done it. We did it the end of June, I think. It was a day and a half. And basically what he's talking about, the sequential intercept, is it marks at what point people interact with different branches. So like the first interaction is usually the police, and then the courts, and then the jails, and then the community, right? And so it was it's for everyone to get in the same room and sit down and kind of say like, okay, well, where do we overlap? Like at what points are we going to intercept and take them off this track? And so they have done that. So I don't know what Counselor Righty was saying about it. He was there. I thought it was very productive. It was very helpful to bring all those players, I guess, all those people into the room and kind of sit down and at the very least know what other people have and know like, oh, well, now I know that I can send them to social services, or I can't mandate it. I can't force them to go, but I can at least point them that direction. The second part of your question was what? It's not unique to Los Alamos. I know it feels like it, but it's a nationwide problem. Everyone needs more mental health support. In some ways, I think it's worse here just because we're so remote. But there's wait lists everywhere. I mean, I have friends in the San Francisco Bay Area, and they're waitlisted, even though they have world-class medical facilities, med schools, all those things. There's just a huge demand for it. That was part of what came out of the Intercept meeting, was kind of trying to figure out what resources, and the whole point of this is to try to take people out of this pipeline, right? And so the intercepts is where you can intercept them to take them off that track. And so with the police department, we had talked about, at that very first contact, about, different, one of the officers had come from, I think, Maryland. It was Maryland. And when he was out there, they had a team that when the call is determined to be like a mental health crisis, they have a whole different team that responds. And so, I mean, setting aside the issues of safety, they still have to secure the scene, but then once they assess or establish that this isn't a criminal, this isn't a criminal act, this is a mental health crisis, they have I forget what he called it, but they have a different team that comes in, and then they stabilize them, whether that means they have to hospitalize them, whether that means they contact their doctor and get them medicated, whatever it is, they have a whole different protocol for dealing with that type of thing. And so we talked about trying to implement something like that here. Somebody asked how it would affect the caseload. That's hard to say, because intervene sooner, like in childhood. I mean, like.
I mean, just from my personal experience, I've seen people that it's more of like a nuisance than a threat. And it's like, well, we can't do anything else with this person.
So. There is now, I wish they would have done it differently. Let me just say it that way. There is a program now where you can, someone can be referred for, it's behavioral health. I forget what it's called. I should have brought the paperwork, but it's a behavioral health thing, but it has to be, I can't refer someone. The best I can do is say, I don't think you're competent. You need to go for an assessment. This program would be, it can come from a family member, a household member, like a roommate. It can come from a doctor. But for whatever reason, it can't come from the courts, because I'm like, if I had the ability to send them to this program, and it's through district court, and it's non-punitive except for, the idea is to get them compliant with their medication and treatment. And it's for mental health. But, I mean, they're so comorbid, right? Mental health and substance abuse. And they're just, it's to tease out which came first, So there is that program. The state is very much aware and trying to move toward more of the behavioral health supports. But in my personal opinion, it needs to start as children. Like, if you look at the studies, especially with domestic violence, that, to me, a lot of this stems from just like the childhood experience. And, and it's generational, right? Like if you had a terrible childhood, you don't really know much different. And so oftentimes you replicate those issues with your own kids, and then it keeps going. And so I think you see a lot of substance use, and even in Los Alamos, like when I did teen court, a lot of the drug use, in my opinion, I'm not a doctor, it's just a Band-Aid for something else that's going on. And if you can't address that, then we're just gonna be doing this all the time. And so I think that the state's on the right track with trying to focus on this behavioral health thing and giving families and other people in their lives like the ability to refer them to this program. It just started. We'll see how it works. I just was shocked, frankly, that they rolled it out, and then I had someone, I'm like, oh, this would be perfect, and then I can't refer them. And I feel like that was a huge oversight. I realize they don't want to make it a punitive thing or a court thing, but I feel like I'm not going to fix somebody's abuse problem by putting them in jail. I'm not going to fix them by putting them on probation. But on the flip side of that, I do still believe, until it's proven otherwise, I do still believe that for some people, just that hanging over their head is an incentive. It's not a cure, but I think some people will take it as an incentive to follow through with their treatment or stay in treatment, knowing like, well, it's either treatment or jail. So fine, I'll stay in treatment. So taking away that sort of stick, I think kind of leaves people without a lot of incentive. And not for everyone, but I don't know if that answered your question, though. No? Any other questions? Yes, sir. Oh, is that it? Oh.
I'm sorry for this question. In the months since November 2024, how, if at all, has your thinking changed on jury nullification?
Why November 2024?
Possibility of criminalizing reconsidering
So that's an interesting question. Jury nullification. When I first started practicing, it was the jury could tell on a juror that was not deliberating, and then they took it away. So I started practicing in 2000, and I think it was gone in California within the year. So prior to that, we used to advise our juries in closing, or tell our juries in closing, like, you have to follow the law. The judge has given you the instructions. You have to follow this. And if someone is not, you need to report it. You need to report it to the judge. And then they stopped us from doing that. So that would seem to me, at least in California, and maybe it's changed. It's been 10 years since I practiced out there, but it would seem to me that jury nullification is kind of accepted. I'm not a fan of it because I think that you take an oath as a juror to uphold the law, and it's not always easy because the law, you may not agree with it, but you have to apply the law.
So last time I was called for jury duty, the pretrial questions were screening for informed jurors and were disqualifying anybody with a ridiculous made-up scenario. But
what kind of case? Was it a civil case or a criminal case?
It was a DUI.
Okay.
And it was very clear what they were screening for.
That's usually part of voir dire.
Yes, in voir dire.
Yeah, so voir dire is the where you quiz the jurors. Like, I personally, when I was practicing, thought it was great. Because it's like a cocktail party. Like, you're just chatting with everyone, like, oh, tell me about yourself. Oh, what do you do? We would cover that in voir dire. So I never used questionnaires. The only time I dealt with a questionnaire was when I was a law clerk, and it was a death penalty case, and it was extensive. But misdemeanors and even low-level felonies, like, we were doing trials every week, so we didn't really have time for questionnaires. I think here they're very common practice because trials are pretty rare, so I think they do try to do those. But I think they're appropriate voir dire questions for jurors is to say, will you be able to follow the law? And it becomes, like, on the death penalty case, it's a very big deal because they're months long, and you have to know. A lot of the questions center on, and people don't think about this, right, until they're faced with the decision. Like, in theory, there's a lot of people who are like, oh, yeah, child molesters, death. Yeah, it's easy to say, but could you really do it? And so a lot of voir dire is trying to make clear to these potential jurors that you will be asked to apply the law to the facts and make your decision. And even if you don't like the law, even if you don't agree with it, it can be, I think it's a fair area for voir dire, and it was one that we spent a lot of time on.
So I think our time is pretty much up at this point. I want to thank the judge for coming and talking to us.
Sure, thank you.